Want to get to a story that is making the rounds right now on social media as Disney wants a lawsuit over the death of a doctor tossed out because her husband had signed up for a Disney Plus subscription and used the My Disney account to buy tickets to Epcot. The information in a series of court filings from the company and the doctor's widower, Jeffrey Piccolo. Dr. Kanokporn Tangsuan died from an allergic reaction, Piccolo says, after eating at an Irish restaurant on Disney World's property. A complaint filed by Piccolo claims negligence by Disney and the restaurant led to his wife's death. But Disney says the terms and conditions of both Disney Plus and My Disney agreed to by Piccolo give up his right to, quote, litigate a dispute in court before a judge or jury. Piccolo's attorney calls that preposterous and fatally flawed, adding that Piccolo's wrongful death lawsuit is on behalf of his wife's estate rather than on his behalf. As I mentioned, a lot to this story here, so I do want to bring in Erin Ehrlich Caro, an attorney, to break it all down for us. Thank you so much for taking the time to be here with us today.
Thank you. Thank you for having me. Good morning.
Of course. Well, I keep saying it, but the story is making the rounds on social media, and a lot of people have a lot of questions overall. Can you explain to me what is really at the heart of this situation, this case here?
Well, I think when you're thinking about what's at the heart of the public's interest in this case, it's really twofold. The first is when you're dealing with subject matter like this, in a case involving a woman's horrible and tragic death, you're wondering how a company like Disney, a big, giant, supposedly family-friendly company, would be making what seems to be a callous and almost petty legal maneuver such as this one. And I think people are not happy about that. And so people are really just wondering how that is even happening. But the other part, of course, and I think this is what's really also highlighted for people, is how this affects us on our daily lives, because how many of us are regularly clicking accept and continue with respect to these long terms and conditions, these dense terms and conditions that even lawyers like myself are not reading. When any time that we need to secure services such as a streaming service, you would never think to actually look at these agreements and be concerned that they were going to have this kind of reach that Disney is claiming.
Well, exactly. And I do want to ask your legal expertise, because is Disney's argument about the Disney Plus subscription, the My Disney account, going to actually stand up? Is that legally speaking possible that folks will say, okay, we see what you're saying?
Well, there's two parts to this from a legal perspective. The first is that, and this is something that, you're seeing a lot of headlines with this being some sort of a cautionary tale. I don't know that we need to go that far. I don't know that we need to be quite that dramatic. But it is important that we understand that these terms and conditions agreements, even though they are not negotiable, we call them contracts of adhesion in the legal world. These are take it or leave it agreements. You do not have the ability to go back to Disney and say, I don't like that term. I don't like that term. Can we scratch this out? It's you take this or you leave it. If you want this service, you're going to sign on the dotted line and move on. So these agreements, even though they are seemingly just on the face of it unfair because you don't get to actually negotiate them, courts have upheld these regularly, recognizing that in these circumstances, it's really impossible for big companies like this to be negotiating with every single consumer. So when we see these agreements, we need to remember that they are generally enforceable. The problem is here that the interpretation and the extension being given to this by Disney in this particular case is a legal stretch. I don't believe that this is going to be accepted by the court in this case in Florida, because the court's going to say, yeah, that contract is enforceable, but how could a gentleman in executing an agreement for a streaming service have any ability to contemplate its effect when his wife is in Disney Springs having a meal and things go terribly wrong? How could they expect that this is going to apply to a personal injury case years later? It's an extension that would be really far outside the scope of what that agreement was about. If something came up with Mr. Piccolo with respect to the streaming service, if there was a dispute with respect to the services being provided thereunder, then yeah, he'll be faced with arbitration. However, the extension, just because of the verbiage in the agreement that applies to the affiliates of Disney, it's really too big of a stretch for the court to say that that is fair and equitable under the circumstances.
And I do want to ask, what would you advise this man if he was your client? Important to note that he is not your client, but
Yeah.
what would you advise him to do in this case?
Exactly what they're doing. His attorneys framed it out perfectly. They explained that this is a preposterous argument. It is really a novel argument to try to make this kind of extension, to try to argue to the court that this subscription service agreement, now forever in perpetuity, puts Mr. Piccolo at risk of always being subject to arbitration in any dispute with Disney in any context whatsoever, is really untenable. And I think his attorneys have pointed that out, and I think they're going to succeed on that argument. And I think also it's important to note, and you pointed this out at the front of this segment, in which this is something that seems to be getting glossed over a little bit in the coverage on this case. This is actually not him suing in his individual capacity. This is not Mr. Piccolo coming to the court and saying, this is my lawsuit. He's there as the representative of an estate. It's his wife's estate. She did not sign that agreement. She was not a party to that subscription service agreement. So even if Disney could get by on that argument, I think they're going to have a tough time pinning that on Mr. Piccolo as the estate representative.
And my brother and sister-in-law are both attorneys, and they essentially refuse to sign anything that has terms and conditions. So I actually don't know how they have access to anything. Yeah. But what I did want to ask, just based on your legal expertise here, is do terms and conditions of just everyday things, maybe streaming services, just anything else you would sign up for, have information like this in there? Do they have anything similar to this?
Arbitration clauses are very common. And you know what? They're not scary. They're not bad. They're bad in this context because in a wrongful death suit, getting in front of an arbiter is not as effective as getting in front of a jury of your peers. And this case really deserves to be in front of a jury. But in a traditional context, when you're talking about a dispute, such as a dispute that may come up if you're having a problem with Disney with respect to the services being provided on Disney Plus, it's economical and sensible for a case like that to go before an arbitration. And so we shouldn't be scared of that. Those arbitration clauses are going to be there. They are enforceable, just like these contracts of adhesion, these take it or leave it agreements. They are going to be enforceable for the most part, but the courts are not going to let something happen that is truly inequitable to consumers, because in the end, the consumer does not have the ability to come to the table and ask for these agreements to be changed in any way. So they're going to be construed against the drafter. That's customary textbook, hornbook law. And so ultimately the company is going to have to come to the table to show why the unfavorable or inequitable provisions are going to be enforced against the consumer. So I don't think that the public at large should be all that worried about this. Arbitration clauses really aren't as scary as they seem, and they do make sense in most contexts.
Do you think other companies, other folks will look at this and think, well, I can say the same thing? Do you see any sort of reaction here from other companies, or do you think not so much?
I think they're going to see how this shakes out with Disney, but don't forget that companies of the size and magnitude of Disney are not just in this to win legal battles. They're also very, very careful about their image, their reputation, their goodwill. And right now, the move that's been made here has really done some pretty severe damage to Disney's reputation. And I think companies are watching this saying, yeah, I don't know that this kind of argument is really worth it if the public is going to take such a negative position in response, if the public's going to be so put off by this kind of legal maneuver. I think that companies may still take pause before following in Disney's footsteps, even if the court actually grants this application.
And before I let you go, I do want to ask one question just as a legal expert to get your opinion, because all of this information that's been received has actually come from members of the media who did look up the court documents. They read through everything. So again, want to get your opinion. How do you feel about the fact that reporters, media, other folks out there can actually reveal all of these details because those documents are public? How do you feel overall about that?
You know, there are moments in my own practice where I feel uneasy about the amount of information being disclosed to the public as a matter of public record when we're engaged in litigation. But the flip side is that these cases are necessary to instruct us as attorneys and practitioners and as parties to lawsuits as we go forward to understand how our facts down the road may work in light of what's happened in the past. And so attorneys especially are regularly looking at case law, at prior histories to see what's going to happen for our cases as we're preparing to litigate them. So, you know, it is a little bit of a mixed bag in that regard. And, you know, certainly in cases that are sensitive in nature, we do want to be extra careful. And of course, the court does have the ability on the party's request to put protective orders in place should there be really truly sensitive information such as trade secrets, business operations being unveiled in proceedings or in litigation or in court documents. Protective orders are there for parties to use, but I think for the most part, you know, the benefit of seeing how these cases are playing out is in everyone's interest.
All right. Erin Ehrlich Caro, thank you so much for taking the time to join us here and break it all down. Anything else you want to add about really any of this before I let you go?
I think the takeaway here is that people shouldn't be quite as alarmed. You know, these agreements, even when you look at them, if you happen to open them up, they are scary to read. Even as attorneys, we don't like to read them. They're very dense. There's a lot of legalese. They're really just onerous documents. We shouldn't be so alarmed by it. Ultimately, these agreements are a lot of boilerplate. They're just saying things that we expect with respect to our being able to use certain services and products. These arbitration clauses, they are standard. They are not scary. They can be scary if they're applied as Disney wants it to be applied here. But because I think it's a long shot argument, I don't think that the public should be walking away from this all that alarmed. We should just be mindful that these agreements are enforceable, but that if something is truly onerous or truly inequitable, you can apply to the courts for relief and they may be able to aid you.
All right. Erin, thank you again for taking the time to join us and break that down. Obviously, a story that will continue to develop and we'll follow here on Live Now from Fox. Thank you again.
Thank you so much for having me. Have a great day.
You too.